Hello, this is attorney Susan Ingles with South Carolina Legal Services. This presentation covers some hot topics in auto fraud, warranties, lemons, yo-yos, and repossession. There's so much law that applies when it comes to cars that we're just hitting a few hot topics today. It's so important to know your rights when it comes to cars, whether it's buying a car, financing a car, or when you get into trouble and you're having a car repossessed, or you're sued over something having to do with your vehicle. So it's important to know there's federal and state laws that can be very helpful to you as a consumer. In the federal law, here's just a few examples. There's a Federal Odometer Act, which prohibits tampering with your vehicle's odometer. The Magnuson-Moss Warranty Act, which has to do with suppliers, warrantors, or contractors failing to comply with a written warranty, implied warranty, or a service contract, which a service contract sometimes seems like a warranty, but it's not. A warranty warrants that the car will be taken care of, whereas a service contract is actually a contract that you purchase for an additional amount for repairs to be made that are outside of a warranty. Also, the Truth in Lending Act, which governs disclosures that must be made to you when you're financing a car. When it comes to state law, really the top three are the laws on repossession, the lemon law that we have, and the Dealers and Distributors Act, which protects you from unfair, false, or deceptive acts by a dealer. So here's some common problems. We're not going to talk about all of them in this presentation, but just a few. But I want to mention these common problems. Okay, you might have a lemon car. If you have been sold a defective car and the dealer or manufacturer refuses to fix, refund, or replace it. There are laws that protect you in South Carolina. Yo-yo sales. Have you been given a final loan contract and then after driving away, you're asked to come back and sign a new one with a higher interest rate, a larger down payment, etc. That's a problem. But there's laws that protect you. False advertising. Getting lured into the dealership with a particular advertisement that turns out to be deceptive and there's no way that you can get that deal. Finance problems. Did the dealer undervalue your trade-in car, conceal some optional add-ons during the negotiation, or even inflate the invoice? Those are common problems that we see. And then, of course, repossession. Was your car repossessed without the creditor notifying you ahead of time? Or after they repossessed it, did they follow the law that protects you after repossession? So problem number one, we'll talk about three different ones. Problem number one is the lemon law. Now it only applies to new passenger cars. So how do you define a lemon? Well, it has a defect that impairs its use or will lower its market value substantially, and the manufacturer cannot repair it within a reasonable time. So you do have to give them an opportunity reasonably to fix the problem. Here's what is covered by the law. Defects that substantially impair its use, its market value, as well as its safety. So, for example, if the brakes don't work, and after going back many times to have them fixed, they're still not working, that may be a situation where the lemon law will protect you. So what do you do if you discover a defect? Well, again, you presume that the manufacturer or dealer can fix the defect during the terms of the express warranty, and that's of course when you need to notify them. And you can't be required to pay for the repairs. And also it has to be within a reasonable amount of time. If there's something that you notice right away, you don't wait a year to take it in and notify the manufacturer and try to get it fixed. Now, the law presumes that giving the manufacturer a reasonable amount of time to repair is 3 repair attempts for the same defect, or 30 days out of service for repairs, and those don't have to be consecutive. So what happens if they're not able to repair the defect? Well, the manufacturer can rescind the agreement and refund the money, but it has to be for the full purchase price, less some allowance for the fact that you may have been using it for a year or however long. They can also replace the vehicle. So how can you get a refund or replacement for the car if they haven't been able to repair it? Well, before you request that, you have to first participate in any arbitration procedure that the manufacturer has. And after that, if you're unsatisfied still, then you can file an action in court. But just remember, you need to have all your paperwork saved. You need to have records of every time the car has been taken in for repairs and just for routine maintenance. Those will be important. Problem number 2, yo-yo sale. People get into this problem a lot because you go in to buy a car, you pick it out, you test drive it, and you say, this is the one I want. You get the financing for it right there at the dealership. They give you the temporary registration tags, and you think, okay, good, I'm done. I'm ready to drive it off the lot and start making my payments. But in the yo-yo sale case, the dealer hasn't actually notified the DMV, and a couple days later, or however long, they contact you to say, oh, wait a second, we can't do that deal. You're going to have to come back and bring the car back and sign a new agreement, and that'll have different terms, but you never know what's going to happen. And once you drive that car back onto the lot, you are sort of surrendering your freedom when it comes to the whole transaction. So it's important that you keep in mind that once you sign that credit contract, it's a contract. You have the vehicle, and they can't go back on the deal. Problem number 3, repossession. Before repossessing for a missed payment, the creditor has to send you a right to cure notice if you've been in default for more than 10 days. Then you have 20 days to pay the missed payment. If you make the payment, great. It's as though you never missed the payment. However, if you miss another payment, they don't have to issue you another right to cure notice, and we can often get fooled by this, thinking that we're going to get another notice if payments fall behind again. So keep that in mind. You get that one notice, and after that, it's keep those payments current, or your car might get repossessed. Also, there's other reasons that your car can get repossessed that don't have anything to do with a missed payment. The creditor might say that you don't have the insurance coverage, or in some other way you've jeopardized their collateral, and when that happens, they don't even have to send you the right to cure because there's really nothing to cure. But you do have the right, of course, for example, in the insurance coverage situation. If you actually do have insurance coverage, then you can challenge that repossession and say, here's my insurance coverage, I've had it all along, or I just changed companies, and but so that's a good thing to remember, that if you do change insurance, or if you change your address or anything like that, you've got to notify your car financing creditor. Now, here's a couple of rights that happen, or that you have at repossession as well as after repossession. I think they're both worth mentioning in this short presentation. One is self-help repossession, and that is that when the creditor believes they have the right to repossession of the car, they can do it without going to court. They just come and pick it up. The only condition is that they can't use force, they can't breach the peace, and they have to be able to take the vehicle without going into your dwelling or your residence. So if your vehicle is in a garage that is closed, they can't try to open the garage and get your vehicle that way because they're entering your dwelling. Also, once they do have the car in their possession after the repo, you are entitled to notice before they sell it, and there are certain requirements about that notice. You can see here it has certain specifics. You know, you've got to have a description of the car, telephone number, and mailing address, so that you've got all the information in order to potentially reinstate your loan, pay it off, get the car back, bid on the car, etc. Now, the notice doesn't have to be phrased in a particular way, but it does have to have sufficient information. And we'll see on the next slide what that information is. The notification has to be sufficient even if additional information appears at the end of the form. So sometimes there's a lot of information there, but as long as they have all of the required information, it's okay for there to be some additional information. Now, sometimes there might be errors in the information. As long as it's not a misleading error, or maybe it's just a typo, that's not going to be a strict situation. Now, there may be other laws that apply here when it comes to repossession, but those are laws that we don't have time to go into in this presentation. This slide just has the list of everything that needs to be in that notice of sale that you get after a car is repossessed. Okay, warranties. There are two types of warranties when you buy a new or a used car. There are express warranties and there are implied warranties. Now, the express warranties are very specific. They can be written or spoken, but they have to have been said, communicated to you in some way. Usually an express warranty is in writing. It might come in a kind of a package deal. And an express warranty can even be created by a description of the car. Now, a verbal representation by a dealer might be an express warranty, but don't assume that, because sometimes a court may say that that was just puffery. That was just a kind of a salesman talking. You do have some obligation of your own to make sure and protect yourself when it comes to express warranties, and be able to differentiate between what's a real expression of warranty and what's just a salesman trying to sell you a car. Almost every new car, and some used cars actually, will come with some type of written warranty. It's always important to read the warranty Not just assume that what a dealer tells you or salesman tells you is in the warranty or what it covers. You should look at it yourself and make sure that you know what's covered. And also, one other thing on express warranties, sometimes they are mistaken for a service contract. That's not a warranty. Now, an express warranty and a service contract might require problems with the car to be repaired. But one is saying, I promise, or we promise, that this is what's going to happen with this car. This is what you're getting when you buy it. It's all part of the sale. But an extended service contract is separate. It's sold for an additional price, and it's a contract between you and whoever the warranty company is. So again, make sure that you yourself read the warranty and make sure you know what you're getting. Implied warranties. Now, these are different. These are implied by law. There's 3 types of implied warranties. The warranty of title, warranty of merchantability, and the warranty of fitness for a particular purpose. The warranty of title, it essentially says that the person selling you the car or the company selling you the car has the title, and that there's no liens on the title. In other words, if there's any money owed on the car, that's been paid. Now, the implied warranty of merchantability is essentially saying that the car is fit for driving, which is what a car is supposed to do. You're supposed to be able to drive it and get from point A to point B. If there are minor problems, those are not covered by the implied warranty of merchantability, typically. Now, the implied warranty of fitness for a particular purpose. This is where a dealer or manufacturer warrants that a car is fit for a certain particular special purpose. For this to arise, you've got to make sure that the seller that's selling you the vehicle knows that purpose. And we've actually had cases in South Carolina where the dispute was, did the seller of the car or vehicle know what the buyer thought they were getting from a specialty standpoint? The buyer is relying on the seller's skill and judgment to recommend something for them to buy that's fit for the particular purpose that they are wanting that vehicle for. Okay, disclaimers of warranties. Always read the disclaimers, because you may think you're getting a warranty that you're not getting. So most dealers and manufacturers do have disclaimers in their contracts. They're trying to do their best to limit any warranties, and that's why it's so important to read not only the warranties but also the disclaimers. Now, they're allowed to use disclaimers, but they have to do it properly. Now, first of all, an express warranty cannot be disclaimed. You've expressly said, here's the warranty for this car, here's what it covers. You can't then say, oh, but by the way, we disclaim that warranty. Implied warranties for fitness for a particular purpose are a little different. They can be disclaimed, but only if the contract provides clearly and conspicuously that all implied warranties of fitness for a particular purpose are disclaimed. And of course, be careful when you're buying a used car, because those warranties are much more likely to be limited or disclaimed completely. So again, the written word is so much more important than what is said to you. You know, after the fact, you can't say, well, they said this would be covered. Not if it's not in the written document. And keep in mind that federal law does require dealers to give you that basic warranty information on a window sticker. And if a car is sold as is, the sticker has to say that. And that means they're not even warranting that you'll make it off the lot in that car. So be careful about buying cars that are as is. The price might be great, but you're probably not getting much of a vehicle. You can find out more about these issues with autos with some great online resources. Our South Carolina Department of Consumer Affairs and 2 other government agencies from the federal government, which are the FTC and the Consumer Financial Protection Bureau. Transportation is so crucial to employment, being able to get to your job, being able to get to the doctor, getting your kids to school, and other issues. So we know how important transportation is. You can contact South Carolina Legal Services if you are having legal issues regarding the purchase, financing, repair, or even repossession of your vehicle. We're a nonprofit law firm, and our legal assistance is free if you're eligible and your case is accepted. There's no guarantees of that, so you do need to apply. You can apply by telephone, or you can apply online at our website. And if it's an emergency, perhaps you've been sued or your car's just been repossessed or about to be repossessed, in emergency situations, you can apply in person at one of our 9 offices around the state. And we invite you to visit our Law Help website. That's lawhelp.org/SC, where you'll find materials and resources on this and other legal topics that we cover. Thanks so much for listening.